Hi, I'm Dan Collins, a Sacramento, California licensed real estate broker and court-appointed referee in partition actions with expertise in real property matters involving probates and trusts. I'm also a California licensed general contractor, and I act as a court-appointed receiver administrator for the Superior Court. If you have found yourself tasked with being an executor administering a probate or a trustee in an estate, I can help you effectively execute your duties that attorneys do not help you with. To learn more, please visit my website, collinsfiduciarybroker.com. Today, I want to talk with you about what to do when you're settling an estate that has unsecured or credit card debt. Some self-help books on probate recommend that if the decedent had credit card debt, you should cut up their credit cards and mail them to the credit card companies with a certified copy of the death certificate. Without meaning to be too judgmental, I think this is a silly idea, and I would never recommend you do such a thing. You are a fiduciary when you act as a personal representative or as a trustee. Your duty is to protect and preserve the estate's assets, not the bank or credit card company's assets. Do not do more than the minimum required by statute to notice credit card companies. My recommendation is you take some time, if the deceased had credit card debt, to work to reduce the balances owed to the credit card company. Sometimes it's as simple as asking for a discount. Sometimes just by explaining the debtor is deceased will get you a 25% reduction in the balance on the credit cards. Sometimes the credit card companies will forgive the debt, but if they don't, the estate may be required to pay it in full. So, be sure to ask the question if the balance can be adjusted to a lower amount given the fact that the person has died. Every estate is required to provide notice to creditors or potential creditors when someone dies. In fulfilling your duty to notice creditors, my recommendation is to request your attorney's firm mail the required notices. In California, the probate courts often require the notice be prepared and mailed by a third party. You are oftentimes not allowed to self-notice. The PR or trustee can handle the required step to publish notices to creditors in a local public periodical as duly required. In noticing creditors, absolutely do not do more than you are legally required to do. My recommendation, do not mail credit card companies death certificates and don't cut up the cards and mail them back. All of that is just a wasted effort. You may not realize it, but credit bureaus, Experian, Equifax, and TransUnion collect an enormous amount of information about you, whether you like it or not. They regularly and routinely sift through and collect all court documents through a third-party company called LexisNexis. As soon as a probate case has been opened, those credit reporting agencies will have access to probate court filings via LexisNexis. That legal service information is available to all three credit bureaus, and they may note on the credit file that the owner is reported deceased before you even provide notice to them. In the case of joint accounts, yes, you should contact the credit card company directly to report that a joint account holder has died. The remaining persons on the account will still be liable for whatever is outstanding in the balance. They may ask you to send a certified copy of a death certificate. In that case, it's appropriate. Even just calling them is essentially a courtesy because they would find out sooner or later from the credit bureaus. So, what happens if someone dies owing $20,000 in credit card debt and you don't contact the credit card company? After 120 days of non-payment, provided you have posted the proper notice, the credit card company will write off the account and send it to collections. At that point, the deceased person's credit score will drop dramatically. As it turns out, creditors typically have 120 days to file a claim against an estate after they have received notice from the personal representative or the trustee. After that date, if no claim has been filed, they will simply be out of luck. The estate will not be obligated to pay the creditor. Your obligation is to comply with the statutes and post the required notices. That's it. So why would anyone notify a credit card company beyond the minimum statutory requirement? If you call the company directly, of course, they will tell you that the estate must pay any outstanding balance, but the reality is that it's unlikely that a probate court will care. On undocumented debts owed by the deceased, once someone dies, that debt is, for practical purposes, uncollectible in 99% of the cases. If there is no legal requirement to call them, I suggest you don't bother. You will only serve to frustrate yourself and them. Unsecured debts are the lowest on the priority list for any probate estate, which means that there would be a lot of paperwork and possible legal expenses to collect what might ultimately be pennies on the dollar. Here's the bottom line. You should always let unsecured creditors be responsible for their own obligations after you have given proper notice. You don't need to go out of your way to help them. That said, if you are talking about unsecured debts from the gardener or the pool cleaner, those are moral judgments, and I would suggest that those people should be paid ahead of any bank or credit card company. Utilities can sometimes also fall into the category of unsecured debt, but the difference here is that you may need to keep paying them if you want to use them. Utility companies are often quasi-government agencies. Since most have a monopoly status, and I have seen them be tenacious bill collectors, if you still need gas, electric, water, or sewer services, you may need to make peace with them, and you should expect to pay them accordingly. For claims such as gym memberships or club memberships where a 30-day notice to quit is usually required, I would tend to ignore those. If you send such companies a certified copy of a death certificate with a letter stating that the member has died, few legitimate operators will press their claim. My name is Dan Collins. I act as a fiduciary broker in probates and trusts that involve real property assets. To learn more, please visit my website, collinsfiduciarybroker.com. Thank you for joining me today.